Hello and welcome to episode 13 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
I'm Joanna Barron, Executive Director of the Canadian Constitution Foundation.
And I'm Christine Van Gyn, the CCF's Litigation Director.
In today's episode, we'll discuss how the Supreme Court of Canada has once again decided that mandatory minimum sentences set by Parliament amount to cruel and unusual punishment.
We'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land.
We'll tell you what we know about Justin Trudeau's new appointment to the Supreme Court of Canada.
But first, let's talk about a lawsuit that aims to fight back against some of the blatant anti-Semitism that's unfortunately bubbled to the surface in recent weeks. Christine, tell us about the lawsuit.
So this story stood out to me for a couple of reasons. First, because I know the lawyer who is bringing this case. And second, because I obviously, if you listen to the podcast, know I'm very obsessed with the issue of the rise of anti-Semitism while this Israel-Hamas war is taking place. And we're seeing all this anti-Semitism kind of erupting above the surface that I've kind of learned was always there festering. I just wasn't really quite aware. So this is a lawsuit brought by a lawyer named Catherine Marshall. And I know Catherine. She has previously been on the board of our organizations, for full disclosure, currently not on the board. But she brought a human rights tribunal complaint for 25 Jewish members of Canada's largest public sector union, CUPE. These are 25 individual human rights complaints. And they're brought against the union specifically, alleging discrimination and anti-Semitism. And this has been following some pretty awful tweets and social media posts by the union's Ontario president, Fred Hahn, in the immediate wake of the October 7th massacre of Israeli civilians. So on Thanksgiving, October 8th, the day after the massacre, when we've all learned about the scope of these atrocities, Hahn tweeted, "As we think about reasons to be thankful, I know I'm thankful for the power of resistance around the globe, and resistance brings progress," which I think rightfully is seen by many as an amplification of Hamas's October 7th messaging that it was not a terrorist attack, which it obviously was, but it was instead some type of justified resistance, which it obviously was not. It was the murder of babies and children in pajamas, and 200 people have been kidnapped. So he also posted a Palestinian graphic with the phrase "from the river to the sea," which is a translation from an Arabic phrase. And it's a common call to arms for pro-Palestinian activists. It calls for the establishment of a state of Palestine from the Jordan River to the Mediterranean Sea, erasing the state of Israel and its people. It's a rallying cry for Hamas. And while some people say this expression can have different meanings to different people, it obviously has a very clear meaning for Hamas, and it means the eradication of all Jews from Israel. And it is a choice for Western activists to use this phrase, knowing what Hamas means by it. And the anti-Israel activists who chant it, whether they know it or not, or maybe whether they intend it or not, are endorsing this extreme violent ideology of the Iranian mullahs, of Hamas and other terrorist groups who are intent on destroying Israel. Now, CUPE was quick to make excuses for Hahn's actions, saying that this was just a backlash of online trolls affiliated with the Israel lobby, and they sort of doubled down on the narrative that Hamas's clear war crimes perpetrated against civilians were merely an exercise of Palestinians' rights under international law to resistance and armed struggle. So Hahn's tweets are not the sole basis of this claim. There was also a tweet from McMaster's CUPE Local 3906 on the day of the massacre. When we were seeing this footage, they tweeted kind of cheering it on, saying, "Palestine is rising, long live the resistance," accompanied by a rose emoji. So obviously quite disgusting. Now, according to this human rights claim for 25 different Jewish CUPE members. Hahn also told Jewish members that he doesn't, on a previous occasion, that he doesn't believe that Jewish people should live in Israel and that Israel stole the land from Palestinians. And it has other, incidents like a CUPE resolution from 2018, which said Israel was illegally occupying the former Palestine, and a 2021 resolution to oppose the International Holocaust Remembrance Alliance's definition of anti-Semitism, and a 2023 emergency resolution to conduct member education about the history of Israel's, quote, occupation and colonization. It also alleges that CUPE produced and distributed infographics claiming that Israel's ethnically cleansing Palestinian people. And it says that the claim says that the union silenced Jewish members. There's one allegation that a camera and microphone of a Jewish delegate to a virtual convention of CUPE was cut off because she was wearing an IDF t-shirt. Meanwhile, members of CUPE were allowed to raise Free Palestine flags on their screens as they spoke. The claim also alleges that the union intentionally or unintentionally held events during Yom Kippur, which is the most holy day in the Jewish calendar, and that this reduced the ability of Jewish members to participate in union events. So as I said, these are all separate human rights complaints brought by 25 members. It's not a class action. It's 25 individual complaints. And I do think that the number of complaints is growing. And apparently it's all being done pro bono by this Catherine Marshall lawyer who I know. Now, this is all based on reporting. I haven't read the complaints itself. And look, I generally have pretty not good feelings about these human rights tribunals. I think that they tend to overstep their role. I think that they can get weaponized, usually by progressive activists. So I generally don't like this type of thing. But hey, I guess give these activists a taste of their own medicine. I have no thoughts really on the prospect of success of the claim, although I do think that the $500,000 damages being claimed here is outrageously high. I don't think discrimination claims will typically get you an amount like that. It's not going to be anywhere close to 500,000. There's also a claim in here for the Jewish members in the complaints to allow them, they're seeking an order to allow them to redirect their union dues to Jewish charities. I think there's zero chance that the tribunal will agree to do that. But what I do think this complaint does that's interesting is it creates some public pressure on the union president, Hahn, to either be removed from the organization or resign, because I think his comments are abhorrent. And I do think that the comments are anti-Semitic, no matter how you spin them. And, the union has defended Hahn, saying that this is just expression in support of Palestinians. But I do think that there is discrimination in those comments. And I think if I was a member of that union, I wouldn't feel comfortable at all around anyone, let alone a leader who appears to be cheerleading and celebrating murder, which is my interpretation of Hahn's comments. Although as I've said, he says that there's a different interpretation. Josh, any reaction to this lawsuit by Catherine Marshall?
Hahn is an anti-Semite. I think that's pretty clear. And I think these comments are abhorrent. And I'm glad to see people are going after him. Whether this is like the right means to do that, I'm not sure, because like you, I haven't yet read the complaints to the Human Rights Tribunal. But I want to say I also noticed there are some lawsuits out there that are getting creative involving students who feel they've been victims of anti-Semitism, and the claims. There's one here in Toronto going after a few universities, and I saw there's one at the University of British Columbia as well. And the argument seems to be that there's a standard of care that universities have to meet in terms of protecting their students from anti-Semitism on campus, and that they're falling below that standard. And to me, this seems pretty novel. I don't know too much about whether it'll succeed or not, but it'll certainly be interesting to watch. Joanna, what do you think about this?
Yeah, well, on the York University lawsuit, which is a class action lawsuit being brought by Diamond and Diamond, which is this big and somewhat beleaguered personal injury firm, I just think it's dumb that they're bringing it as a class action, because the whole thing with class actions is that it takes a long time to certify the class. Like that's the major procedural hurdle. And the other thing that's kind of, to say the quiet part out loud, is that class actions make lawyers a lot of money. So I'm a little cynical of the motives in that. In terms of Fred Hahn and CUPE, I just think this is a distillation. His comments, his whole worldview, as much as I can glean it from his comments, this is just a perfect microcosm of the problem that the left has just shored up in the last month, that everything is cast in oppressor-oppressed politics, and therefore within their worldview. I think a lot of these people haven't been to Israel, because if they did, they would notice that calling Israel a white supremacist settler colonial nation, which oppresses people of color. If you get to Israel, you quickly notice that a majority of Israelis are of Mizrahi or Sephardic descent. So they are the same color as Palestinians. There's also Ethiopian Jews. There's also Black Jews from the US, many of whom have immigrated. Like, I think you'd be shocked by how diverse Israel is. I was very quickly spotted as a foreigner when I lived there, that it's like that it fits neatly into their worldview, just shows how ignorant they are. And it's also no coincidence that Hamas has picked up on this. And Yahya Sinwar, who's one of the leaders, compared the Palestinian plight to the racist killing of George Floyd. So even though Hamas vows to destroy the West and all of its values, they're cynical enough to know how this rhetoric works. And so I don't know what's going to happen with this claim. I share Christine's cynicism about human rights tribunals, but I do think that it's good to amplify and just be clear that these comments and this ideological positioning is harming CUPE's Jewish members. And the comments are anti-Semitic, right? Criticizing Israel is not anti-Semitic, but calling into question the legitimacy of the only Jewish state is anti-Semitic. So that's all I will say about that for now. Josh, let's talk about, we have a new Supreme Court justice. Yay. So what should we know about her?
Yeah, so the Prime Minister has done it again. 2 years ago, he managed to make history by appointing the first person of color and Muslim to the Supreme Court, Mahmoud Jamal. Last year, he did it again by finding a judge who is not only female, but also Indigenous and bilingual and from Ontario, Justice Obansawin. And he's managed to pull another rabbit out of his hat, finding a judge who is not only, female, but also Francophone and from Alberta, which is a hard thing to find. So I'm, of course, talking about our new Justice, Mary Moreau, who was sworn in this week to replace Justice Brown, who was forced to retire because an ex-Marine punched him. This decision brings the Supreme Court back up to its full strength, which is 9 justices. And it's being celebrated because it's the first time the Supreme Court will have a majority of women on it. And I do think diversity is important, including bilingualism. That's obviously a strength, but the Supreme Court has immense power to shape our lives. So to me, we should probably prioritize, experience over things like race or gender or bilingualism. But the Prime Minister seems to think otherwise. And I'm not saying like any of these 3 judges won't be like a particularly good judge, but even with Justice Jamal, it's too early to tell. I just think that we're excluding some of the best candidates by focusing so much on whether it's, the first or history-making appointment. With that rant over, I'm going to tell you a little bit about what we know about Justice Moreau and some of her background. And I gleaned a lot of this just from watching the hearing that she did before Parliamentary Justice Committee the other day. And my general impression is she seems like a nice, smart person who's not particularly ideological, apart maybe from the issue of minority language rights. And this, by the way, is what a few Albertans who I spoke to have told me their impression is, that, she's nice and not particularly ideological. And that's probably a good thing in a Supreme Court judge. But like I said, she has these strong views on minority language rights. And that's because being Franco-Albertan shaped her own life story. As she told the committee, her grandfather left Quebec, moved to Saskatchewan, and then her father left Saskatchewan for Edmonton, where he became a surgeon and an advocate for French language rights. Moreau has 7 siblings, and she has 4 kids of her own with her criminal defense lawyer husband, and she's got a grandchild on the way, she said. Justice Moreau is 67, which means she'll hit the mandatory retirement age in less than 8 years. And that makes her appointment, a little bit of a surprise because prime ministers like to appoint judges who will be on the court for decades. Her first big case, the one that launched her career, is also kind of telling. It was a case where an alleged trafficker of cocaine was pushing for the right to have a jury trial in French in Alberta, which is really hard to do because, like I said, there's very few francophones in Alberta. And then Moreau got appointed to the bench at age 38, which she admits is earlier than most judges. And she says is due to the fact that she was a francophone judge in Alberta at a time when the government was looking for francophone judges in Alberta. And she says there was some backbiting about this appointment, but it just made her work harder. This particular anecdote kind of reminded me of former Chief Justice Beverly McLaughlin, because she was appointed at age 37 and rapidly promoted. And she said that, part of the reason she was appointed at such a young age and her career trajectory was so straight and narrow was the fact that she was a female judge at a time when politicians suddenly decided they needed to appoint female judges. So it looks like the same luck sort of befell Justice Moreau. One thing I did notice is she seems to be on board with, I guess, what I would call sort of more mainstream but kind of woke policies. So, for example, she introduced smudging and the eagle feather for Indigenous witnesses in courtrooms. And I gotta say, I find the smudging thing a little bit hokey sometimes because obviously it's an important practice for certain Indigenous nations, but white people seem to think that, Indigenous nations, all of them smudge and that it's part of all of their cultures, which is not really true. And it kind of sent me back to law school where we had an Indigenous speaker come and do a talking circle. And the point was to try and make us understand Indigenous people better. And he did some smudging, which was voluntary. I personally opted out of it because it's a spiritual practice and I just didn't feel comfortable doing it. Also because this elder, I think I told you this story before, Christine and Joanna, he had just finished telling us that there was no sexual assault in Indigenous cultures pre-contact, which I found kind of offensive and hard to believe, as if Indigenous people are not prone to all the horrible atrocities that every other people are prone to. But anyway, it was funny. When this started, I was like, no, I'll just pass. And then a couple other people passed. And then it got to this one girl and she stood up rapidly. Her chair fell back and she just ran. She bolted from the room. I guess she was very, I don't know, maybe she thought it was witchcraft or something. But anyway, back to Justice Moreau. So,
which it isn't, right? Obviously.
Yeah, I don't think we need to say that even. It's just, it's a spiritual practice. Some people believe it and some people don't. But anyway. So Justice Moreau also, she was talking about how she brought in a 2S LGBTQ1 plus member of the community to speak to judges. And I thought this was funny because I was like, oh, 2S LGBTQ1 plus, that must be some new acronym that just dropped. But I think that it doesn't actually exist. And the one that she's talking about there is just an I. And so she might need to brush up a little bit more on her 2S LGBTQ acronyms. She was also talking about how she does, international judges training. And that's a good thing for advancing rule of law. But at the same time, I don't know if that's something Supreme Court justices should be doing necessarily, because their job is to decide cases. And as Yuan Yizhu pointed out the other day, they only decided 54 cases in the year 2022, which is 6 per person, if my math is correct there. Maybe they should be more focused on cases than the judges training. But I'll just finish by quoting her. So Justice Moreau said, quote, "You can never take it for granted that the rule of law is truly cemented firmly because it does take the trust of Canadians." And I think that's true, but I think, sometimes when you get a little bit into these woke sort of political conversations, that it can actually harm your trust with Canadians, because a lot of people are are not on board with those particular political views. So I agree with Justice Moreau, and I wish her luck. Supreme Court's really important, and I want them to get decisions right. So, Joanna, what are your thoughts on the new Supreme Court pick?
Well, I'm just like curiously optimistic. We don't know a ton about her, so I also wish her all the best. One thing that I thought was funny was some of the commentary around the majority female bench now at the Supreme Court, which also reminded me of one of our favorite podcast reviews, which we mentioned last week, that we have too much estrogen and too little testosterone on this podcast. Well, the Supreme Court is now also estrogen dominant. But there's a joke that I think in the 90s, Bertha Wilson, when Claire Leroux-Dubé was appointed, she turned her and said like 2 down, 7 more to go or something like that, which raises the question, like, is it a goal to have an all-female bench? And why would that be? Anyways, obviously, I think appointments should be according to their merit and also certain principles of geographic representation. But I don't really have anything else to say about Justice Moreau. Christine, do you have any thoughts?
The only thing I don't think you mentioned this, Josh. The headline from the Globe and Mail article announcing her appointment was, "I consider her a fighter," which was an interview from some lawyer in Alberta who knows her. And there was some commentary about this, like, is that what you want in a Supreme Court justice? Like, perhaps what you want, and keep it, these are not her words about herself, it's someone's description of her, but like, perhaps rather than a fighter, we want like someone judicious. And I'm not suggesting she wouldn't also be judicious. It's just an interesting perspective on what certain lawyers value in an appointment to the bench.
Yeah, I agree. I think it was Andrew Coyne who said that, and I agreed with that comment. As much as it's fun to, talk about judges' personalities and things like that, I think what we want is for them to, set aside their particular biases and life experiences and just focus on what the law is. But it's a pretty unpopular opinion. Joanna, let's move on now. Let's talk about your news headline. Everybody's talking about this case. I haven't actually read it yet, so why don't you fill us in?
Yeah, so this was released last Friday. It's called RV Bertrand Marchand, and a few reasons why it's kind of buzzing. There's 2 topics that tend to get a lot of chatter in the law world. The first is mandatory minimum sentences, and the second is sort of morally egregious crimes such as child luring. And in this case, the court ruled that applying mandatory minimums to the offense of child luring is unconstitutional. This was a 6-1 decision, and I'll mention the dissent in a moment. But the majority found that the mandatory minimum violates the right in Section 12, which protects against cruel and unusual punishment. The majority, written by Justice Sheila Martin, found that the mandatory periods of incarceration apply to such a wide scope of conduct that the result is grossly disproportionate, which is, she's speaking in the language of the test under Section 12, cruel and unusual punishment, in reasonably foreseeable scenarios. Majority examined this question in reference to 2 specific cases, both of which involved the use of the internet. And so they found both that the internet makes it easier for predators to get in touch with children, making children more susceptible to exploitation and abuse. And they also found that the dangers of sexualizing children is increasingly well documented and the harms are more fully understood. So this went both to the breadth of the offense, so the range of conduct that could be caught by child luring, but also the issue of the medium and its effect on the message. For example, Justice Martin said certain applications require users to indicate they are at the age of majority and old enough to be present, but it can be bypassed. So the first of the cases was an individual who pleaded guilty after having sex with a girl 4 times over the course of 2 years, beginning when she was 13 and he was 22. The fact that he's relatively young will be kind of important to the court's analysis. And he was sentenced to a 1-year mandatory minimum, which is the mandatory minimum for this offense. Of course, given the specific factual scenario, and if there are aggravating circumstances, of course, this is just a minimum. The sentence can be higher. And the court found that this 1-year sentence in the case of this individual who had penetrative sex with a child was not unconstitutional. Yeah.
Oh my
it's
God.
icky. Not unconstitutional, but they found that in other reasonable hypotheticals, which I'm going to talk about in a moment, it could be unconstitutional. And then the other appeal, so often the Supreme Court will hear two together because it raises the same issue, was another person who challenged the 6-month mandatory sentence where the Crown proceeds by summary conviction, which is just a different procedure, usually for less serious crimes. This case was a bit different. The individual complimented the intimate body parts of his 16-year-old niece and godchild at a family dinner while they were alone, and then sent inappropriately sexual text messages. So lesser in severity.
That's still really disgusting.
Do you know how old he was? Just out of curiosity.
It doesn't say.
Okay, never mind.
Yeah, so I'm not sure. So the court found that the constituent elements of the child luring offense are so broad and unconstrained so as to capture conduct that is only remotely related to the heart of the offense, and that's what makes mandatory minimums constitutionally suspect. They said Parliament, which of course imposes these mandatory minimums by statute, could have designed it to allow judges the power to apply an exemption where they found that the right against cruel and unusual punishment would be violated. And they found that where Parliament creates criminal offenses for broad purposes and wide applications, which applies where they have a mandatory minimum to all sentences without use for discretion. So judges have a sort of allergy to mandatory minimums because, of course, it deprives them of their discretion in sentencing appeals. So there's always, you always see judicial pushback against these. You kind of understand. It's like judges are a hammer. Their job is to hit the nail, and you're telling them you can't hit the nail. You have to just apply the mandatory minimum. So Justice Suzanne Cote, who is known as the sort of queen of dissents. She dissented in this case. She was the only dissent. She found that the sentences, the mandatory minimum, was not grossly disproportionate, nor contrary to Section 12 of the Charter. She found that while the offense is broad in scope, it also requires a high level of mens rea, so meaning mental intention, a mental mind state, which ensures that the offense captures only conduct that involves a high degree of moral blameworthiness, as well as serious harm or risk of such harm. So I don't know what you guys think about that, but I want to kind of zoom out to a meta issue that has been raised by this case. I assume, because I've heard from a few journalists who wanted to talk to me about this, is you see in these mandatory minimum Section 12 cases, the use of reasonable hypotheticals. And I don't actually know if this is a Canadian thing or it's also in Commonwealth jurisdictions. I know that it's not a US thing. So it's basically, even if the sentence isn't cruel and unusual in the case of the person that's actually in the case at hand, can we imagine a scenario that would still fit under the offense where it would be cruel and unusual punishment? And the judges drew on reasonable hypotheticals in this case, and they have in all of the mandatory minimums. So it's like, well, what if there was somebody who was a youthful offender who was 18 and knew what he was doing, but it wasn't penetrative? You know, they would look at a scenario that could pop up. And this practice is kind of controversial, has attracted a good amount of criticism. The main arguments against the use of reasonable hypotheticals are that they obviously have an air of unreality. Like, it's like judges are just making stuff up. They're just imagining things. So it's sort of unmoored from any predictability or consistency. And then one of the things judges say in their defense about this is that, well, this is just common sense that this could come up. well, if it was really common sense, why would it be argued at the Supreme Court of Canada? And obviously Parliament disagrees that it's common sense, and Parliament has brought in these mandatory minimums to signal their denunciation and deterrence. And then finally, it's like, well, okay, if there's a reasonable fact scenario that could arise, why don't we just wait until it does arise rather than make stuff up? So I think those are kind of trenchant critiques. On the other hand, I will say, from the position of the work that we do at the CCF, I see why there is a usefulness to asking about the reasonable scope and application of the law as drafted to determine its constitutionality. And so when we challenge restrictions on free expression, for example, we will look at something kind of similar to reasonable hypotheticals. Like in our Calgary City protest ban, we said, well, if you're banning all protests to do with gender and national identity, what about a woman life freedom, pro-Iranian democracy protest? What about a female genital mutilation protest? I will say there the rationale is different because it's about the chill effect. It's about chilling otherwise lawful expression, and it's quite different from somebody who has been convicted of child luring. But anyways, I'm curious to hear if you guys have thoughts on this.
I think part of it's not quite the same, right? Because the Calgary case we're bringing as a public interest litigant without the facts on the table. So it's not a case where there's an individual whose rights have been breached and we're challenging it. We are challenging it in the abstract. So I think in a case like that, it is appropriate to talk about these reasonable hypotheticals on the facts of this case that just went to the Supreme Court on child luring. It wasn't just one case. It was a group of cases with facts in play, and we saw how the law was being applied. So I don't know the why this focus on the reasonable hypotheticals. And whenever I see judges do this, and they do it, like judges like asking these hypotheticals. And often when I see it happen, the lawyers are the ones who don't like it. Like, well, that is not the case before you. The case before you is my client who has done X, Y, and Z.
Criminal defense lawyers like it. So either way, one last comment that whatever we think about it, and I'm curious if Josh has thoughts, it seems like the use of reasonable hypotheticals is here to stay, because this was directly before the court in a decision that was released March of this year called Hills, where the use of reasonable hypos was directly challenged, and they said, no, it's valid, but they did attempt to rein them in a bit and circumscribe them to say that the hypothetical must be A, reasonably foreseeable, B, in the range of conduct contemplated in the offense, and C, may consider personal characteristics without being too removed or far-fetched. Not sure what is meant by that. But Josh, any thoughts on reasonable hypotheticals?
I'm of two minds about reasonable hypotheticals. Like, first of all, they're really fun to come up with. So I like it from that aspect. And also more seriously, a lot of these issues, like I think we just pointed out, the Supreme Court is not deciding a lot of cases. So if you have, a legal issue and you're not sure where the actual line is between what's constitutional and what isn't, it is good, in my view, to have the Supreme Court provide some guidance on that, which they do when they consider these reasonable hypotheticals. But I actually think the bigger issue, just hearing your, summary of that case, which I haven't read, is Section 12, like cruel and unusual punishment, I think is being sort of stretched well beyond what it was intended for. And it's supposed to be reserved for those things that are really obviously grossly disproportionate. And it seems like the courts here are as they often do, taking power away from the legislature that has, studied this issue, consulted with the public, and decided that no, if you are engaged in child luring, you have to go to jail for, 6 months or a year, which seems like a reasonable place to draw the line. So I'm more concerned about sort of the abuse of Section 12 than reasonable hypotheticals. But I guess we know now that they're here to stay.
Joanna, did the court consider, I know a lot of Section 12 cases, like the case of Bissonnette, which was the mass shooter in Quebec who shot a mosque up and killed many people there. One of the things the court considered in that was this notion that in his case, it was about stacking of parole ineligibilities, and they talked about how that would shock the conscience of Canadians. Did they talk about that in these cases?
They didn't as much. They did talk about the relative youth of at least the 22-year-old offender, where they were like, well, if you look at the effect on the rest of his life of doing a 1-year prison term, given that he's relatively young, like it could mess up his ability to like get a job for the rest of his life. That went into the cruel and unusual punishment. But again, that person had penetrative sex with a 13-year-old 4 times. So
yeah, I think the whole notion of the shocking of the conscience of the public, when judges talk about that, I think they just don't understand the public, because I think that
it shocks the conscience of like elite judges, right?
Yeah,
but not normal people.
It shocks the conscience of the public that these people are not like in jail for life. That is what the public wants. So I think that part of the test is not. I don't know. I think there's a problem with it because the judges are so removed from what the public actually thinks. Okay, let's move on. We'll take a break and then I'm going to give my freedom update.
Hi, I'm Russell from the CCF. In case you haven't already, make sure to subscribe to our email newsletter, The Freedom Update, to get updates from me every week about our ongoing work and the legal stories in Canada that keep us interested. It's one of the best ways to stay up to date. Subscribe at theccf.ca/freedomupdate.
Okay, so my freedom update this week, just one of the things I'm working on is I have a new ebook that is coming out that's going to be available for free for all of our listeners and subscribers and CCF supporters. So the book is called Healthcare Choice in Canada, Innovative Policy Solutions to Improving Canada's Failing Healthcare System. And it's going to be available at theccf.ca/healthcare book. Now, the book is a collaboration with a number of different organizations, and we've commissioned essays from some of the thought leaders on healthcare choice in Canada. So I have an article, an essay in this book about healthcare choice through the courts. There's an article from the Macdonald-Laurier Institute about patient choice and how it drives quality in medical care. There's an article from the president of Second Street, another charity, about preventative healthcare. The Fraser Institute has an essay about how measuring healthcare performance is a way of creating greater accountability. The Montreal Economic Institute has included an essay about how European models on aging in your own home can save money for Canadian governments by reducing institutionalization. And there is an article from the Frontier Center for Public Policy on the role that politicians can play in healthcare choice. So that's going to be available on that website, and anyone who has the link can download it for free as one of the resources that we want to give to everyone who supports our work. So that's it for me. Let's move on to bad legal takes. Josh, what's yours?
Mine's from Emmett McFarlane, who's a political scientist at the University of Waterloo. McFarlane's probably best known for taking like some really insane positions during the COVID-19 pandemic. There was never any like lockdown or curfew or rights restriction proposed that he didn't support, and he'd kind of like viciously go after anybody on Twitter who raised any opposition to that. McFarlane's obviously also known for his work on constitutional law, which is sometimes reasonable, often quite interesting. But I think this latest opinion is not great. So McFarlane told the Regina Leader Post that despite Saskatchewan's legislature having passed legislation that invokes Section 33 of the Charter, the notwithstanding clause, to require that schools not use preferred pronouns of kids under 16 without parental consent, a court could somehow still declare the law unconstitutional by using Section 28 of the Charter. And for those who don't know, Section 33 says legislatures can allow an act or provision to operate notwithstanding for 5 years if they do so expressly in legislation. And this text pretty clearly shows that, you know, it overrides the rights in Sections 2 and 7 to 15 as long as it's done expressly in legislation. And this exists because provinces retain some level of supremacy, even though the Charter's constitutional supremacy clause exists. And it sort of exists because, judges aren't always right. And sometimes legislatures need to push back. So anyway, McFarland is saying that Section 28, which says, quote, notwithstanding anything else in this charter, the rights and freedoms in it are guaranteed equally to male and female persons, is a trump to Section 33, which is the actual notwithstanding clause. And he says this means, quote, it doesn't apply in contexts where sex discrimination is at issue. Section 33 does not extend to bills that have a disproportionate impact on sex. And this could be extended to a context where sexual identity is the characteristic under attack by a law. And if you've never heard of this magical trump card in Section 28, that's because it doesn't exist. Section 28, of course, exists, but as people like University of Alberta Assistant Professor Gerard Kennedy has pointed out, along with many judges, by the way, Sections 25 to 31 of the Charter are interpretive aids, and they don't protect any substantive rights. So this means basically if Section 33 is operating notwithstanding a provision in Section 2 or Sections 7 to 15 of the Charter, there's nothing for these interpretive aids to interpret because they basically never come into play. And the Supreme Court has considered Section 28 13 times, and this is all discussed in Gerard's paper, which we'll put in the show notes. And Section 28 has always been seen as just an interpretive aid. So, for example, if the case is about freedom of expression, Section 28 might help the court decide whether a limit's demonstrably justified if it's going to enhance equality between the sexes, but you can't just use Section 28 as this trump card and claim your rights have been infringed. The case Hack and Attorney General of Quebec is probably like the leading case that explains that Section 28 doesn't override 33. And in that case, it was argued that, Quebec couldn't use the notwithstanding clause to ban wearing religious symbols, which is an obvious violation of freedom of religion because, Section 28 provided some sort of trump card over Section 33. Justice Blanchard came to the same conclusion that nearly every other judge came to, and that's that Section 28 is just interpretive. And so, Emmett, just like everything you talked about COVID related, I think you're just plain wrong on this one, and you're my bad legal take of the week. Christine, you have one from a regular producer of bad legal takes. Tell us about
generally.
Bad takes generally.
Mine is from Nora Loretto, who I think has just like the worst opinions about absolutely everything on the internet. She's this woman who said that people were only sad about that tragic Humboldt bus crash where all of those kids died. She said people are only sad because the kids are white. Like, so disgusting, these opinions she has. And I think she does it on purpose. Like, I think that she intentionally tries to have bad, provocative takes to get people mad. So, I mean, she does. It works. So she's been tweeting some pretty awful stuff about the Israel-Hamas war. And to quote her, Zionist doctors, which I think we all know is a euphemism for something else. But this one stood out to me. This tweet that I'm going to read stood out to me because it related to my news headline, which was that members, those Jewish CUPE members suing CUPE. But it more stood out to me because it is so lacking in any self-awareness. So in response to Catherine Marshall's announcement of that human rights complaint against CUPE, Loretto tweeted, "Fuck democracy, lawyers are the ones who should decide," which is unintentionally so hilarious because I think all of us here on this podcast are probably, somewhat of judicial skeptics. I think we have concerns that the court regularly bulldozes over the will of the legislature, whether it's the case that we just talked about that Joanna did of, mandatory minimums, or the Bissonnette case of the mass killer at that mosque, and the stacking of the parole ineligibility. The court said, that's got to go too, or limits on euthanasia for mentally ill people or people with drug addictions or even people just with allergies. The court said those limits have to go too. The court said no to the legislature's will on supervised injection, on brothels. I mean, I could go on and on. Quite literally, this phrase Nora Loretto used cracks me up because I can actually see myself using it angrily in response to one of those decisions.
So it's a good legal take?
No, because I don't think she knows what she's saying. I can even see the Supreme Court earnestly putting that in one of their own decisions. I just think it's a bad legal take because Nora Loretto does not feel the same way about all those other cases. And look, as I said, I have some skepticism about these human rights tribunals generally, but I don't really think that Loretto's phrase applies to this CUPE case. But it sure applies to all these other cases, and I may in fact have to steal it and start using it myself, but with different intent. Joanna, what about you? What's your bad legal take?
So mine is a bad legal take co-signed by, at last I checked, over 550 members of the bar. So this was an open letter. I'm not sure who actually wrote it, but in its own copy, it says it was drawn up in response to pervasive repression of speech and scholarship on Palestinian liberation. Law students and lawyers are being threatened with academic sanctions and job loss for advocating against Israel's atrocities in Palestine. And so signed by over 550 members of the bar. And I was talking to our friend Asher Honigman about this, and he pointed out that this letter is a classic Mott and Bailey. So I just read you the sort of preamble. And they talk about cancel culture and being bullied. But then they also say, we reject the notion that it is anti-Semitic, hateful, or illegitimate to contextualize the October 7th attack. Similarly, we reject the notion that it is anti-Semitic, hateful, or illegitimate to express support for Palestinians in the face of ongoing Israeli apartheid and genocide. So we've already talked about the genocide argument and the apartheid argument, but really the Bailey part, the part that's being conflated in, I have nothing against people who want to advocate for Palestinian rights or share the Palestinian narrative. I actually just listened last night to an interview on the Ezra Klein show with a Palestinian scholar and activist, and I found it very useful. The part that's being smushed into this is the part about quote unquote contextualizing the October 7th attacks. When we know, and we've already mentioned in this episode, what those attacks consisted of. Contextualization must not become relativization. But look, we know by the specific positions that have been expounded on by specific signatories of this letter, like Heidi Matthews, who tweeted that there's a lot of obfuscation about what the right to resistance looks like in brutally asymmetrical contexts. And she tweeted that the day after October 7th. So in other words, calling October 7th justified resistance and justifying, face-to-face massacre of innocents as well as kidnapping. So that is very different from saying that people who want to speak up for Palestinian liberation should be protected and shouldn't be bullied. And our colleague Sean Speer had a great piece last week called "The Left Has a Self-Policing Problem." And this is what he means, that there's a lot of unsavory stuff that's trying to be rolled into otherwise fairly shocking endorsements of violence. So yes, for the 550 people who signed this letter, this is a bad legal take, but good to know who you are. Josh, you want to close us out?
Yeah, so as usual, we hope you'll rate us, review us, and subscribe. And I really do mean go rate us and review us because it helps us. And if you do that, I might tell you what I really think about the new Chief Justice. I'm only kidding. I already told you everything I know about her. Just a reminder, you can support our work by subscribing to the CCF's YouTube channel, by following us on Twitter, or by visiting our website, theccf.ca, where you can sign up for our Freedom Update newsletter written by our colleague Russ. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.